Hello, Assalamualaikum.
Waalaikumsalam.
Hello, Assalamualaikum. Hi, good morning.
Morning.
Okay, can we start now?
Yes, doctor.
Okay. Can everyone can see the slide?
Can.
Okay. 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 What slide that we stopped last lecture?
Matters to be neglected.
Matters to be considered. Okay. Okay. Matter to be neglected in determining compensation. Okay. Okay. I have another meeting at 11. We need to stop by 10:50. Is it all right? Okay.
Yes, doctor.
Okay. Today's class is up to 10:50. 10:50. Okay. Method to be neglected in the determining compensation. In determining the amount of compensation to be awarded for any scheduled land acquired under this act, the following matter shall not be taken into this consideration. This time is a shall not be taken into consideration. Okay, neglected. Should be, oh, sorry. Okay, should be A, the degree of urgency which has led to the acquisition. What actually the meaning here? The degree of urgency which has led to the acquisition. Looks like contradict with section 19, isn't it? Acquisition under the case of an emergency. Am I right? Section 19, section 20.
Yes.
Okay. That one is under the acquisition under the agency which led to the acquisition. But this one here said that cannot be taken into consideration. Looks like contradict with the requirement of the section. Can someone try to guess? Is it contradict or not to contradict? Hello.
I think no, because certificate of urgency, it's that taking the land during the emergency. Like when we doing the compensation, we cannot take into consideration this element. We awarded like normal compensation, right? It's not like during this, if we taking possession on the land, their certificate of urgency, the land value will be lower or higher.
Okay. Normally, whatever work we do, for example, if we ask someone to do it fast, for example, let's say you want to renovate your house, for example, renovate your house to just extend one room of your house. Normal contractor construction time is, let's say, 2 weeks. But you say that because you need it urgently, you ask the contractor to do it in just 5 days. What going to happen with the cost?
Higher.
Higher higher than the normal two weeks, isn't it? Supposedly 2 weeks, the contractor will charge you 15,000. But if you want the contractor to finish it in 5 days, then the contractor might say, if you willing to complete it within 5 days, you have to pay 25,000, for example. That is the meaning of this. Shall not taken into consideration. The degree urgency which led to the acquisition shall not, even though the government used the section 90. Looks like urgent, but the agency will be treated when there is a building on it. Then you will that one is the agency will be treated. And I have to pay you. I have to pay you the building first and the cost of transfer for everything, but not the market value of the land. That is the meaning of this A. Okay. Government try to protect the situation where they need the land urgently, but don't want to pay higher. Okay, by having this clause. Okay. Okay, understand it? Hello.
Doctor, what is
Understand.
meant by the degree of urgency?
Degree of urgency is the level of urgency.
Level.
Degree means level. The degree of urgency, the level of urgency. Whether you need it urgently. Okay, let's say you just put in a section 8 on the land acquisition, but you want it next week. Normally take a month to before you can enter the land. But this time, because of the, let's say, of the flooded area, then you need to construct whatever the center for to manage the flood. Then you need to construct the building very fast. Then the government will use this thing under the certificate of urgency. Then the government can go into to the land, even though the market the land the compensation is not yet quantified. That is the example of this the clause A. Okay. B, any disinclination of the person interested to part with the land acquired. What actually this meaning under the normal situation? Anyone want to try to explain this one? Any disinclination of the person interested to part with the land acquired.
Hello, doctor. Can you hear me?
Not clear. Very looks like you are not in Malaysia. Very far.
Hello,
Okay.
doctor. Can you hear me?
Now very clear.
Okay. My understanding on this clause is because some lands will have a different proprietor, not only one, but maybe more than one. So there are all different
multiple owners lah.
Yeah, multiple owner. So if the valuation is carried out like based on any bias or like not fair to all people, then this value should be then this matter should be neglected. Cannot be do like this.
Oh, it's not like that. The meaning of this clause B is different. Liguan just now.
Yes.
Okay, Liguan, it's not that. Your explanation a little bit is a little bit different from the what actually the meaning of this clause B. Read properly the sentence. Any disinclination of the person interested to part with the land acquired. What actually the meaning?
So we don't need to take into consideration how much the owner doesn't want to surrender their land. So
Yeah.
basically the value has nothing to do with that.
Okay. Close. That is a close explanation. Meaning that this is to cater that those landowner is reluctant. The word disinclination is a reluctant to give, to surrender, to give, to be a part with their land, because it's so love with the land, very sentimental with the land. Can you remember that the one that I told you about the old man with the orchard durian trees in Tanjung Malim?
Yes.
That is the meaning. Because this is very subjective thing. Yeah? You know that some people is a very have a love and affection with their property. They don't want to be a part with the land acquire. Then because of that, then the government will be having a difficult if the government try to consider this point, meaning that to make them be a part with their property, sometimes they are asking for ridiculous amount of compensation. Meaning that if you have a you must understand, even though you love your property so much, you cannot be a part. The meaning that under this clause, the government does not care. Okay, I will take your land and I pay you accordingly based on the market value at that particular time. That is the meaning of this B. Okay, let's go on. Hello. Okay. C. Any damage sustained by the person interested which, if caused by a private person, will not be a good cause of action. This is very legal terminology, legal statement of the law. Anybody try to describe this thing? What actually the meaning of this?
It's like someone not from the government that tried to destroy the property, but in determining the compensation, this matter will be neglected.
Okay, close, but can you elaborate further, Iqbal?
Contohnya lah, just someone by private person would not be a good cause of action ni, like destroying someone's property, like dia buat khianat lah.
Ya, okay. Contoh dia buat khianat tu?
Macam dia robohkan pagar atau tiang, macam tu lah.
Okay, very good. Okay. The word here is any damage sustained by the person interested. Maknanya tuan punya tanah lah, kan? Okay, dia terpaksa menanggung kerosakan. Any damage sustained by the person interested, if caused by a private person, orang lain, orang pihak ketiga, private person, another, dia punya kawan ke, dia punya jiran ke, person yang nothing relate with the acquisition. Tetapi tindakan itu is not be a good cause of action. No. Tindakan itu misalnya dia pecah, kata macam tuan mention tadi, dia demolish the fence, whatever the thing, and then the for a retaining wall, for example, dia rosakkan, and then because now the person, the interested person suffer loss of support, kan, for his land, And then tindakan itu bukan tindakan yang memberi kebaikan. It's not be a good cause of action. The action is not they just give a damage. Tetapi kadang-kadang bagi damage, ada tindakan itu untuk memberi kebaikan. Ada tak siapa yang boleh beri contoh? Ada tindakan yang merosakkan tanah tetapi dia beri kebaikan.
Tak tahulah. Ada rasanya.
Ada. Contohnya kata tanah dia berbukit sikit. Tapi di belakang tanah dia tu ada sungai. Air dah bertakung di depan. Dia terpaksa lah korek sikit tanah dia. The private person ni, orang kampung lah. Korek dia punya tanah sedikit untuk bagi air lalu yang lebih cepat dekat. This is a good cause of action. Even though damage the person. Faham?
Faham.
Macam itulah. Tak boleh ambil. Kalau dia good cause of action, kena ambil kira lah. Ya? Yang damage yang dia tanggung kerana kerosakan tu kerana orang udah ceroboh tanah dia untuk buat saluran air supaya air boleh discharge lebih cepat. Okay? Yang tu kena ambil kira. Tapi kalau just not be a good cause of action, then you have to. Kena faham yang tiga ni agak ada trick sikit. Okay?
So, if any damage tu can a good cause of action, so it will be included in compensation lah.
Bayar balik, repair balik lah ataupun something like kalau boleh repair, the government have to take action to repair balik lah. Janganlah biarkan je tanah dia jadi because of that ada parit yang kena buat tu tanah dia dah terkurang jadi RM1 katalah RM2 dah jadi RM1.50 sekaki persegi. Then you have to give RM2 lah. Faham?
Alright, faham.
Itu caranya. Okay. D. Any depreciation in the value of the land acquired likely to result from the use to which it will be put when acquired. Okay. Any depreciation in the value of the land acquired likely to result from the use to which it should be put when acquired. Can someone try to give an example for this one?
Like one land, it is originally a commercial land, zoning commercial, but one day got gazette say the land will be used for school. And
for
then,
school?
Yeah. So this will cause in the drop in value when the land is acquired for school.
Yes.
And so this cannot be taken into consideration in the amount of compensation.
Meaning that the intended use of the land, okay, let's say the purpose of acquisition for the school, meaning that the lower value as compared to the commercial value, isn't it? Then this depreciation you can consider. True enough. Another obvious example is if the land, okay, your land is under the residential zoning, for example, but the intended acquisition is for the purpose of the IWK, Indah Water Consortium. You know the IWK?
Yes.
They're going to construct the oxidation pond on your land, and then your land become depreciate because of the pond. Ada dekat situ kan? Ada oxidation pond ni bukan kolam renang tau. Kolam oksidasi tahu tak?
Tak tahu.
Kolam oksidasi tak tahu. Kolam IWK punya kolam. Yang semua discharge daripada you punya toilet apa semua tu you punya then hantar ke situ, kumpul kat situ. That is the task of the IWK. walaupun indah water consortium, tapi they try to make the shit water into good water. Tak tahu ke IWK?
Tak tahu dah.
Takkan nak tahu. Whatever discharge from your toilet itu, then put it into the septic tank, and then the IWK will take it and put it in the and then channel it to the oxidation pond. That kind of pond, and then will be on the land, and then your land will become, for example, your land is 5 acres, acquire 2 acres for this oxidation pond, and then the remaining land will be depreciated in value. Am I right?
Yes.
Can under the principle, the use is will be the damage, isn't it? Damage to your remaining land. You in general idea, in general, you can apply for the injurious affection, isn't it?
Yeah.
But this kind of why the other students so quiet? I just hear the me one, league one, and then Ikhwan. Kenapa apa jadi dengan semua student yang lain? Please answer me. I just dengar Labia, Mingyao, macam tu je. Tapi yang lain tu tak ada. Ikhwan, kata Nur Izwani, are you here? Nur Izwani? Halo. I dah remind banyak kali dah, take part in the discussion. Tak ada pun dalam ni, Nur Azani dia tak ada pada ni. Chua, are you here? Chua?
Yes, Doctor.
Yeah. Okay, Chua, explain to me the requirement of this section D.
Yang HMD saya cakap
3D. Where are you, Chua?
Office. Tadi which part? Sorry, Doctor. Yang mana part?
You are not following the lecture.
I'm in office. Sorry, sir.
Hello, Chua.
Yes.
3D.
3D.
Explain to me again.
Can Doctor open the slide again? Have to open the slide because I'm using phone right now. Thank you.
Okay. Can you see now?
Yes, sir.
Okay, the D. Please explain me the D.
Okay. So, this is regarding the methods to be negated in the bidding compensation. Okay.
Yeah.
If there's any depreciation resulted from the land acquisition, okay, so it won't be taken into consideration for determining the compensation of the land, subject land.
I understand that is stated in the act.
Okay.
Statement. But explain further on them. Give the example of this
example.
In the real life, what actually the example of the acquisition. They make this thing happen?
Okay, let me think. Agricultural land. Okay, example for a piece of land, say it's agricultural land. Okay, that's going to be acquired, and then oh, wait, hold on. Agricultural land, and then the land to be acquisition actually got a development proposal. Maybe say you got a residential development coming up, upcoming. It's going to be acquired as agricultural land, so it loses the value already for the development. Can say like that. So it should be more value, but then it's being acquired already, so it doesn't count in the. That's appreciation. That's increment.
The word here is depreciation.
Sorry.
The keyword here in D is any depreciation.
Yeah.
Okay. Yeah, your example is
appreciation one.
Oh,
my example is appreciation one. Let me think of depreciation one.
I don't know.
Hold on.
Hello, Chua. Hello, Chua.
Yes.
Okay. Don't. I don't want to waste the time. Okay. But you must follow the lecture properly, even though you are at work now. Okay.
Okay.
Ask the meaning that the permission for your boss that you're going to follow the lecture.
Class.
The class.
Okay, sir. Got one example. Example is same lah. Agricultural land is a subject land, and then it's acquired to become a dump site. Yeah, dump site can say so. So it depreciates already, but then it shouldn't be accounted into the compensation to the original proprietor. Yeah.
Okay. Thank you. Correct. I think someone messaged you to get you to the answer. Is it true? Your friend?
Yes, sir.
Okay. Okay, it's okay. Good try. Okay. Okay, I want Amira Alicia to explain to me E, 3E. Amira. Okay, to be fair to everyone, those yang I call online not respond to me, I put note to your name and then I will do something to you. Amira, I give you last chance.
Doctor, she put in the chat that her mic is not working.
Always that kind of the reason.
But she put in the Google Meet chat. You can see it.
Okay. Okay. Amira Alicia, you WhatsApp me your answer. Okay. Or I put notes that you are not responding. Okay. Alicia, you WhatsApp me. WhatsApp in the group of BIE3001. Okay, Melissa, try E.
Hello, doctor. Can you hear me?
Yes, very clear.
I think for 3E, we can use a Chua's example earlier about the agriculture land being used for development purpose.
What? Okay, example of development purpose.
Residential development such as condominiums.
Condominium for what? Hello, condominium for what?
Let's say that the initial land use was for the purpose of agriculture, but then government acquired the land for another purpose. The intended purpose is on for development of, let's say, I can't.
Okay, can you remember section 31A, 31B, 31C, 31D?
31A, 31B, and 31C.
Section
Section 31A, 31C is for public
purpose.
Yes.
B.
For
Without referring to any notes. Tell me.
it is for non-public purpose.
Non-public purpose.
Is it?
Okay. What actually the meaning of non-public purpose?
Land is acquired, but for the purpose of
Okay, Nurosaliza. 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 You are not here. Okay. City one with that. City one with that. Okay, I call only 3 times. Then I take a note. Because I already remind you. Nazahan. Nazahan. 2 times. Nazahan also not here. Okay. Teshuzen.
Yes, doctor.
Okay, what is section 3B all about? And with the example.
3D or 3E?
3B. Section 31B.
31B. Section 31B is for any person or any corporation. They acquire the land for beneficial use or beneficial for the economic development, which is not under 31A for the public purpose.
Okay, perfect. Okay, thank you, Susan.
All right, doctor.
Nur Fazilana.
Yes, saya.
Okay, Fazilana. Explain to me back to our slide. And again, 3E.
So untuk section 3E, dia macam apa nama, kalau ada increasing dalam untuk value untuk land tu, so dia dia kena neglect lah untuk determining compensation. Contohnya macam macam tadi yang
can you speak English because you have your Chinese friend in the mainland China.
Example, if the improvement, if the land is agriculture, but the purpose is to acquire for housing development, so there is an improvement to the value of the land. So the improvement, the increasing of the value of the land to need to neglected to in determining compensation lah.
Okay, your Chinese friend dekat mainland China tu nama apa? Li Wenyu ya.
Yeah, Luna.
Oh, you panggil dia Luna.
Yes.
Okay, Luna, are you here?
Yes, Doctor, I'm here.
Okay, can you understand what all your friend explanation?
Almost.
You lost. Which part that you lost?
The fast just to say something I didn't really understand.
Which one you don't understand? Section 3A, B, C, D, E? Because today we already covered A, B, C, D, E.
For E.
Any person that you like to hear their his or her voice to explain to you? Can you name one of your friends to explain to you? Ming Yao, you are requested by the Luna. Explain E.
Okay.
In Luna language, not in my language. No, it's not Chinese. The English, Luna English style.
Okay. So for section 3E in the first schedule, it depicts that any increment in value due to the acquisition should not be taken into consideration. For example, if the land is acquired, a portion of the land is acquired for the construction of highway, of course the remaining land will have increment in value since the accessibility increase. We cannot take into consideration the increment in value due to the acquisition portion for the highway.
Okay, Luna, can you understand Min Yao English?
Yes, I understand.
You understand? Okay, explain to me your understanding.
If the land is acquired for the highway purpose and the remaining land will be increased in the value. Is it correct?
That is what you understand from Min Yao explanation.
Yeah.
All the time the highway construction will appreciate the value, Min Yao? Is it all the time like that?
I think most of the time, because highway definitely will increase the accessibility.
Yes. How about if the highway is a closed highway? It's not open highway.
Closed highway also.
Closed highway mean you cannot simply go in and out from the highway whenever you like. But you have to go through the toll plaza.
Yeah.
And then let's say the toll plaza is 10 kilometers away from your land, and then you are fenced up by the highway. Is it appreciate in value?
Depends on the acquisition. Is there any accessibility to the land? If yes, then the construction of highway may depreciate the value.
Okay, depends on the situation and how the acquisition happened. Okay, I accept the explanation. Okay, now we move to F. Any outlay or additions or improvement to the land acquired which was incurred after the date of application of declaration and the Section 8 unless such addition or improvement were necessary for the maintenance of any building in proper state of repair, and unless in the case of agricultural land, this is any money which has been expended for the continuing cultivation of crop on it. Okay, understand this? Can you understand this statement? Okay, because if you try to explain to me and then I say yes or no, then you learn more than if I just give you the explanation. Try to, okay. Nazri, are you here? Nazri? Tak ada ya? Okay. Kalau I panggil 3 kali je tau. Kalau 3 kali tak ada, you akan dapat satu, nama you akan dapat satu notes. Then I know what to do. Those yang ada notes.
I'm Linkai. I want to try. Can I?
Okay.
Okay, so this one is about the example. If the land is going to acquire and it is gazetted under Section 8, if I do any improvement, like maybe I do renovation on my building, right? It is not counted as the compensation because I already know that it is going to be acquired, but I still do the renovation on it. But in this case, if I do the maintenance, this is necessary for the building. So yes, the things will be compensated.
Okay.
Okay. In another case of agricultural land, it's the same. If I do the improvement, maybe I do more crops on it. This cannot be compensated. But if I use money on like maintenance, the cultivation of crops on it, yes, it can be compensated.
Can be compensated. Okay.
It is my understanding.
That is a good understanding. But I have to ask you a question also.
Okay.
Okay. Let's say you do the renovation to your house after, let's say, 1 or 2 days after the declaration date of the Section 8, but at that time you don't know about the acquisition. Can you get the...
In this case, I have to tell my lawyer to speak for me that to give the proof that I didn't aware of the gazetted thing, or I can prove that the LA didn't give the notice to me, didn't post the notice at proper place. If I can prove that yes, the thing that I do at the particular time can be compensated.
Okay, you know that the allowable time between Section 4 and Section 8 is 1 year, isn't it?
Yes, 12 months.
12 months, 1 year. Okay, 12 months. Let's say you do your improvement, your not repair and maintenance, improvement to your house. 6 months after the Section 4, but the Section 8 that time not yet gazetted. Can you get the compensation on what you did to your house?
I think, okay, if I am aware of Section 4.
Section 4 you are aware because Section 4 gazetted and then you are not given the notice because Section 4 is not yet determined the exact lot, whatever, but have the indication that you're going to take in that area.
Okay, this is not from any law. I think this is from logical thinking. Even I think when I realize that my land is likely to be taken, I cannot do anything on it already. I have to wait for the final decision come out, then I continue to decide what I am going to proceed. Yes, so that means I cannot do the
but you have done your renovation
That means cannot be compensated.
Cannot be compensated.
Mm.
Okay. How about the principle of no better, no worse position after the acquisition? You are become worse if you are not compensated on that.
No better, no worse
position.
I think that have to depends on I'm doing it at the Mala fight or Mona fight lah. I'm doing it for good purpose or just simply want to mark up the value. It can be
okay. In that case, you will do it in the bona fide.
Bona fide, it means good purpose lah.
With the good intention. Because your family expanded, then you need more rooms. Then you do the renovation. But at that time, Section 4 already released.
So I really don't know.
Okay, in that case, you can be compensated because under the law clearly say that incurred after the date of publication of Section 8, not the Section 4.
Oh, okay. Okay, faham.
Faham, ya?
Strictly Section 8 lah, that means.
Yeah, certainly Section 8. If they start with the Section 4 and then after nearly 1 year baru nak keluar Section 8, that is their lembab lah, office. Their mistake. Okay. Okay. Other student, any question on that? Because based on the discussion, I think you understand more. If I just give you the explanation and then sometimes you cannot catch it. Okay.
Total, I have a question.
Okay. Who are you?
I'm Sujong.
Sujong, okay.
Okay. Because for D and E is a depreciation and increase in value, but we also learn about interest, perfection, and betterment. But that one we give compensation. So I'm a little bit confused how you determine whether this interest need to give compensation or not.
Okay, injurious affection is the physical damage. Okay.
Okay.
The physical damage on the land. Okay. Okay. For this one, because the government is going to protect them to pay and not to pay the thing that they're going to put into the land. This is because of the visionary damage. You know that any deviation in the value of the land acquired likely to result in use. Meaning the use. I mentioned to you, I'm going to take the land for the oxidation pond, for example. Then we're going to depreciate the value within it. Whether they depreciate or not depreciate is still questionable. But in the rule of thumb, in the general principle, the land will be depreciated. But to further protect the government to say put a clause, I'm not going to taken into consideration, because if I put the purpose of the acquisition for the that depreciate the land, then I don't want to be responsible, even though by right you can claim for the injurious affection, isn't it? But they already covered. Put the cover.
So can I understand like this? Like for the injurious affection is something very certain already. Like you maybe from first layer to second layer is very clearly stated already. But for this one, maybe it's something like they say the view is not nice, something like this, very uncertain factor.
Yeah, but yes, but true. But this one, generally people understand if I put in the oxidation pond on part of of my land, you put substantial amount part on land, my other land will be depreciated. You must understand that is a general view. The theory also say like that, but the government also cover. I don't want, because of my purpose of acquisition, you will gain from that. But for the injury patient, that you are certain and physically damaged, you physically injured. But this one is not physically injured, isn't it?
Okay.
Hmm?
Okay.
Physically injured means that I lost of my access road. This is physically injured.
Oh, I understand. Because that one is due to their use. Like if they use to this use, then will injure me. But even though for injury affection, even though they didn't do anything, I still get injured. Like my land is already second layer now.
Yeah.
Okay. Okay, I understand now.
Okay. E also the same thing lah. Huh?
Yeah. Okay. Thank you.
Okay. Okay. Any question on this this part A, B, C until F?
Doctor, just wanna confirm my understanding.
Who's on the line?
Ashwin.
Huh?
Ashwin, AK.
Oh, AK.
Yes. So section 2 and section 3, injurious affection and betterment is due to the acquisition, right? And section 3 is based on whatever the intended use is being.
Purpose of acquisition.
All right. Okay. Cool. Thank you, Doctor.
Okay, clear. Huh? You must be very clear on that. No? Otherwise, nanti you terperangkap dengan ini. That should be why not counted. But the case is the issue is on the purpose, not on the way that the land is acquired. Okay, if no other question on that, I will.
Yeah, sorry, Doctor, I have one question about the 3F.
3F, okay.
For this, you say just now, any improvement after the declaration under Section 8, the compensation should be neglected, right?
Yeah. But
for the
any improvement, not for the maintenance or proper.
Yeah, I know. But for the schedule 2 also, the section 1.3, section 1 sub 3, it said that if the market value of any schedule rent has been increased or is currently increased, the increase shall be disregarded. For example, the increase within 2 years before the declaration under section 8 also will be neglected for the section 1 sub 3.
Yes.
But just now you say that before declaration, the improvement can be compensated.
That one is referred to value, isn't it? This one is referred to the improvement. No contradiction. Okay, let's say we revisit section 1.3.
Section 1.3.
1.3.
This one.
This one. An increase by reason of use of the land or any premises thereon in manner which could be restrained by any court or contrary to law. Okay, this one is about the illegal use.
No, sub A.
Section
3 sub A.
Any increase by means of any improvement made by the owner of considered interest within 2 years before the declaration under Section A was published in Gazette, unless it is to be proved that such improvement was made bona fide and not again. This one before the Section 8. The other one we discussed in F is after the Section 8.
Yeah, just now Min Kai got answer. Doctor, you answer him. If before the Section 8, the provider has do the improvement, then the compensator should be compensated, right? But this Section 3 sub A say that the improvement should be disregarded.
Yeah. Yeah, but if you make it based on the bona fide, then you should be compensated within 2 years. In interest within 2 years before the declaration. What actually your problem between this one and the F?
What can I say? For just now the example given by doctor, right? Okay, let's say that the improvement is done after the section 8. So
okay,
the compensation should neglected, right? Okay, let's say just now if before the section 8 the improvement is done already, then the compensation should not be neglected, right?
Yeah. Let's say I give you the example like this. Okay, you have a house. Let's say agriculture land. I give you the example of agriculture land. Okay, you have one bungalow on agriculture land allowable by the national land code, isn't it? Because for your own occupation under the agriculture land, your bungalow lot, but the rest is agriculture lah. Okay, are you following? Okay, okay. Then section 8, let's say your improvement, you are put a tarmac surrounding your bungalow. Let's say your land is 5 acres of land, but you take half an acre for your bungalow, then you fence it half an acre part of it, then you fence it, and then you put a tarmac for the half acre of land. That is the improvement you made. You made within 2 years. Within 2 years of your the section 8. Okay. Then people may ask you why you need the tarmac. You just because say that you have children, banyak children yang dah kahwin balik hari raya apa semua, no place for to put the car, for example, and then you have to provide the better parking for the family. Okay, that is considered bona fide action. Then that case, even though after that you claim for the cost of the tarmac to put tar around half an acre of area, then that one is claimable because bona fide. This is the example of A, the 3A. When we talk about the neglected, and then after that, the same thing, you know that once you receive section 8, the same case, you receive section 8, then you just put another one more room to extend the building, another room, was it because you said ada another, you ada satu lagi orang mau to cater for the guest room, for example. Okay, that one is cannot be paid, cannot be neglected. You know already, because that one is not for the purpose of the maintenance and repair. That one for extension. This is the example of these two things. Faham?
Temporary faham. Later I think about Kelly.
Kalau you ada lagi example, your own example yang you can ask me. Okay. That is the example that I can give you. Because 3 di sini, 3 ni kata just increase shall not disregard. Dia hanya mesti kena disregard improvement tu, tapi kalau improvement itu malah fide. Tapi kalau bona fide, okay. Faham?
Faham.
Okay. Okay, now can we move to other related matters? Okay, limitation in Airwork. Did Dr. Hasnati cover this one? Not. Cover this topic, section 4? This is hello? Hello?
Yes, we are here.
Okay. Did Dr. Has already covered this topic or not? Limitation on Airwork.
Like haven't.
Okay. If haven't, I have to cover because this is very important for you and to advise your family members as well. Okay. Where any inquiry made by the land administrator under section 12. Section 12 is about the inquiry, isn't it? Or any statement in the writing required by the land administrator under section 11.2. Any person interested has made a valuation or of a claim compensation for any land or any interest therein. Such person shall not any time be awarded any amount in excess of the amount stated of the claim. Okay, let's say you are the landowner for the A. Okay, you are called for the section 12 inquiry. Okay, the LA, legal administrator, land administrator. LA is a land administrator, it's not legal advisor. Ya. Dalam court case kita, LA is a legal advisor. Dalam akta ni kita refer to land administrator. Land administrator always ask this question. Pak Cik, how much you want the compensation? Always that question will be asked by the LA. And then you are the owner say that berapa saja yang government bagi I accept. Meaning that government means the government valuer. Government valuer is the person to advise the LA. The government valuer already prepared the report and then say that the land should be, let's say, 10 ringgit per square foot. 10 ringgit per square foot. And meaning that you are bound to have a 10 ringgit per square foot. After that, you balik rumah and then you have your, let's say this is kata Lik Wan punya father lah, Lik Wan father, then Lik Wan balik cuti, then Bapak Lik Wan mentioned about my land being acquired by the government, and then I already went for the inquiry, but I just asked whatever the government advised to the land, and I agree. And then Lik Wan kata, how much? 10 ringgit. And then Lik Wan make an investigation. Then Lik Wan say that your land should be 15 ringgit per square foot. We have to contest the government. Then if you make like that, under the A, you cannot contest the government anymore because your father already agree with the award given by the government, or he already accept the thing. Understand A?
Understand.
Lik Wan, how to make you still open? Your father need to answer like this. Saya mohon nilai pasaran yang setinggi yang boleh dan apa-apa klaim yang boleh berkaitan dengan pengambilan ini. That means that you put open for you to challenge. Otherwise, you cannot challenge. Because you know that the inquiry is a level of the lower court, and then minuted, then cannot. That is the limitation. The meaning of limitation on Airwork for the A. Any problem on A?
No, Doctor.
So this response will be recorded by the land administrator.
Of course, because that one will be minuted and then bring up to the to the court.
Okay.
Then they say that you cannot claim anymore because you already agree.
All right. Thanks.
Don't simply agree. The tips and my advice to any dispossessed land kalau masa inquiry, try to be greedy. That don't try to be a good citizen of Malaysia. If later on, if you want to agree with the government valuation, it's okay, but you still have the land. Let's say in that case, you cannot challenge. Okay, clear? Okay.
Okay.
Okay, and then on the other part, pula kalau you refuse or omitted without sufficient reason to be allowed by the judge to make a claim to compensation, such persons shall not at any time be awarded any amount in excess of the amount awarded by the land administrator. Dalam kes ini, you jawab macam ni. Tahu? Bila land administrator LA ask you how much pakcik you want for your land, the government going to acquire for the school. I refuse to take any amount. And then you jawab, I refuse to take amount because I feel that the government not fair to me. And then why only my land going to acquire, not the other land? Okay. Bila you cakap ataupun you cakap macam ni, saya pun tak tahu berapa-berapa saja je berdapat saya ambil. Then also you cannot go to the higher level. Refuse pun tak boleh, first pun tak boleh. Ya? Kalau you kata, I refuse, saya tak nak. Because you know that land acquisition is not you to say nak ataupun tak nak. Okay? Can you understand the difference between A and B?
Doctor, I a bit confused on the B. Don't really understand.
Don't understand. Sometimes landowner ni kerana marah sangat their land being acquired by the government sampai dia cakap bila land administrator ask the landowner what do you want to claim and then how much per acre that you want atau per square foot that you want. Say, I don't want anything. I object the acquisition. Then you put the limitation on you to go further up. Tu makna yang B. Refuse. Okay, Mia, boleh faham?
Okay. Okay. So like during the inquiry, the LA will ask this question: how many want to be compensated?
Yeah, they will ask you. Kalau you tidak, you cakap, I don't know how much that I want, but I will engage with my private valuer. Private valuer will send you a valuation report. Cakap macam tu, okay.
So that means
ataupun you know that the area orang jual tanah hanya 200,000 per acre, you cakap saya nak 1 juta per acre. You letak atas tak apa, tinggi. Tapi kenapa kalau you letak 1 million tu, you must be careful with this one had omitted without sufficient reason to be allowed by the judge tu. You kena cakap bahawa be careful sikit lah. Better to put in as my private valuer will give you the amount, what actually the compensation that I want, because must be sufficient reason. Sufficient reason means by the professional or by you. But try to be greedy, okay, to make sure that you have the right to further investigate of to further bring up further case into the High Court. Okay? Understand? This limitation on Airwork is very important. Answer wisely to make sure that you are not trapped by the law that you cannot bring up your case into High Court.
Doctor, so this simply just means we should accept with objection, right?
Yes.
Okay.
You cannot say that accept with objection. Better accept with objection sometimes very meaning that you try to accept, okay, but that one is a legal term lah. In the normally accept with objection tu biasanya orang kampung tak tahu pun.
Okay.
Kalau you are the landowner, maybe you can say I accept, but with my objection. Then okay lah.
Okay.
Okay. Then we tengok ini constitutional right of appeal. Okay, kita nak tengok. Because all the matters with regards to the compensation calculation, all that semua tu yang consider matters to be considered, not to consider everything, then we have to put in our claim. How we going to claim is based on the you know that the market value quantified by the comparison method or any other method that's suitable, and then also take into consideration what is can, what is cannot. Okay. Then the method for the injurious affection and severance on what betterment must be before and after method. Okay. And then now we look into this thing. The provision of Land Acquisition Act, in particular section 40D and 49, severely restrict a landowner right to appeal to the court, appeal against the decision of the High Court in land reference. Section 49 Land Acquisition Act state appeal from the decision as to compensation. Any person interested, including the land administrator and any person of corporation on whose behalf the proceeding were instituted pursuant to Section 3, may appeal from the decision of the court to the Court of Appeal and to the Federal Court, provided they were the decision comprised on Airwork of Commission shall be no appeal therefrom. Okay. Apa maksudnya dekat sini? Provided that where the decision comprises an award of compensation, there shall be no appeal therefrom. Kalau you bawa case to the court, you nak bawa case to the appeal court. Let's say you have been discussed in the High Court. You know that the sequence of the court is the first one is for the litigation is High Court, then Appeal Court, Court of Appeal, and then Federal Court, the last one. Okay, you only decision with regard to compensation is up to the High Court saja. That is the under this section 49, yeah. But in Kalama Sdn Bhd versus Pentadbir Tanah Batang Padang, the Federal Court had the appeal in the land ransom matter to change the award of commission by the High Court was barred the provision in section 40D 3 and 49(1) of the Act. The Federal Court had that there is no right of appeal in that case because the issue of put forward before the court was whether the learned judge was correct in determining the amount of compensation to be added to the appellant. Okay, dalam kes ini dia bagi peluang lagi kerana sama ada nak tengok the compensation itu betul ataupun tak betul, ya. Yeah? Okay, because by the High Court. Okay. That's why dalam kita punya legal system, dalam kita punya mahkamah, always kadang-kadang walaupun stated clearly in the act, sometimes people still on challenge based on the certain ground. Okay, this is for your knowledge only, for the slide 21 until the end. Because other question of law is applicable to the Court of Appeal. This is because such decision does not comprise an award of compensation. The ground is for the, you understand that? The Act says with regard to compensation, you cannot go further up. On other matter, only can go to the Court of Appeal and the Federal Court. But dalam kes Kalamas, allow just because of the decision is a question of law, is applicable to the Court of Appeal because question of law, not because of the compensation. But at the end is with regard to the compensation because they said that the judge ada buat silap di dalam menentukan compensation. Okay, boleh follow tak? And dalam kes lain pula, Tan Wei Mia and 3 others versus Pentadbir Tanah Daerah Gombak, appellant was succeed in setting aside the decision of the High Court in 2 related land reference. In essence, the Court appeal accept our submission that the High Court just had urged in finding that the category of land use of the acquired land was agriculture instead of building. Accordingly, the decision of the assessor were based on the error of law ought to be set aside. The Court of Appeal decided that the land reference was to be heard before a new panel of justice. This is another case show that even though the section 40D says that you cannot bring up any dispute on compensation to the higher court, but this one can because ada kesilapan di pihak judge. Okay, contesting an award of compensation under section 37, I think you dah belajar juga. Okay, person interested who wish to object to the quantum of the land administrator award can be do so via referencing proceeding. This is done by the lodging of Form N to the land administrator pursuant to section 37 of the Land Acquisition Act. However, that person must lodge his objection within the prescribed time limit and must not have fully accepted the award without protest. Reference proceedings are not available to all interested persons. In particular, the land administration provides no objection can be made for the award not higher than 3,000. Meanwhile, for award exceeding 15,000, any government person or corporation that award, which for public utility and whose behalf the land was acquired shall be deemed to be an interested person entitled to raise an objection as to compensation award for said land. You must understand anything below than 3,000 for the individual and 50,000 for the corporation cannot be bring up to the court. Okay, and then okay, this is about the ground of the objection. An important requirement of the Form N above is that it must contain all ground on which the objection is made. Ground not stated in the Form N will be entertained by the High Court in relation to matters of procedures. Only the land administrator is able to refer the objection to the High Court for the determination. Okay. Once the matter is referred to the High Court, the proceeding shall be known as land reference proceeding. During such proceeding, the parties involved are usually the land administrator and the objecting parties as an. I put here the thing because I need you to be clear on your ground of the objection for our moot. Section 40D of the National mandate that the judge shall be bound by finding of the assessor in relation to the issue of compensation. However, the Federal Court recently, Semennya Jaya Serembat, Pentadbir Tanah Daerah Ulangan, Court Semennya Jaya punya case, has declared that this subprovision of Section 40D, this is about the appointment of the assessor, are unconstitutional unconstitutional. Okay. Specifically, the federal court in Germany had that section 30 infringe Article 121 of the federal constitution as they take away the judicial power vested in the judge in the high court to make a determination. Okay. In essence, the decision states that the opinion of the judge should not be binding on the judge in question. The federal court has called for the provision to be struck down. As a result, the judge can now depart from the opinion of the judge and come to his own decision on the amount of the after taking into consideration the opinion of the assessor. Last time, you know what? Why this case being challenged? Last time is you have to judge two assessor. You know, judge only handle the proceeding, and then the assessor will decide what whether the private valuer is right or government valuer is right on the decision, and the judge must take opinion of these two assessor will give their report to the judge, and the judge decide whether to accept one of the report or not. But this time based on this case, the judge now is just listen to the opinion of the assessor, and then he made his own judgment. Because the assessor punya role telah dikurangkan. Just because of sometimes the assessors are not really prepared before coming as an assessor, and then the judge always complain about the assessor. The assessor punya opinion. Okay. I think for class we have finished the class. You can ask me during the hello. Looks like I'm just talking to myself.
Ada Doktor, tadi.
Okay. I hope that you can ask all sort of questions with regards to the compensation, and then for the next class, if we still have the class. This week is a week what? 11.
Yes.
Yes.
Meaning that we have one more week for the lectures, and then we do the more revision on that, and then after that you can ask whatever question you want with regard to the land acquisition compensation.
Doctor, sorry for interrupt for a while. Can you hear me?
Yeah.
Because I would like to ask whether the Carian Rasmi and Carian Persendirian of the title will result in different info or not?
We result in different info.
Yes.
Why info?
Because
I think it should be the same because the source of the info is from the land office. The same law.
Yeah, because actually we face one problem is because our PB1 we got two times status search at different time period, but the results show different proprietor actually. Yeah, so this is our concern. So that's why I asked, because one is Carian Rasmi and another one is Persendirian, Carian Persendirian. And then
should be the same. Should be the same. Cannot be different. If information is different, one party must make a decision, mistake or wrongly take the information.
Oh, okay.
One party must be not enough. But because you are referring to the same information, why should be different? Cannot be different, isn't it?
This is why I confused about it.
Yeah, in real life, actually, I know the government will also do the checking, do the pergi buat carian lah. Okay, and then the private valuer also buat the carian, but you go to the same land office and then refer to the same information of the lot. Cannot be different unless one party make a mistake or wrongly jot down.
Okay.
will be ataupun dia tak tahu nak baca, transfer to this one, atau until the end of the day dia think patutnya ada lagi satu transfer tapi dia ambil sampai transfer yang dan the second last. Then different lah. You are not properly investigated.
Okay, understood, Doctor.
Okay, any other question before we end, because I have to prepare for my 11 o'clock meeting. Sorry for I take your 10 minutes time for preparation of my report, my meeting.
Maybe we'll ask during the tutorial session.
One last question. I can allow one last question.
Then I want to ask for injurious affection. The section got say that injured by his other property.
Yeah.
In this case, I want to ask his other property. Can the other property be the adjoining lot to the also belong to the same owner, but the lot shall the lot be
not taken?
Not taken. If included in acquisition, then cannot count for injurious affection, right?
Let's say you own two pieces of land. One land is subject to the acquisition. The other land is not subject to acquisition. But these two lots complement each other. You give an inject to the land acquired, the scheduled land, but the effect will be not to your other land. Then what can be applied for injurious affection.
If the other land adjoining lot also included in acquisition,
then of course can. Definitely can.
Okay, thank you.
Okay, I have to say goodbye, and then we meet again on Wednesday. Okay.
All right, thank you, Doctor.
Thank you very much for everyone.